asked a room full of business owners what legal risks they're worried about right now, I'd probably hear the same answers. Employment claims, cybersecurity, AI, of course, data protection, maybe shareholder disputes. Very few people would say consumer law, and that's exactly why I think consumer law has become one of the most underestimated legal risks facing UK businesses in 2026. Because whilst everybody is talking about AI, regulators have been quietly handed some of the strongest enforcement powers that they've had in years. And the reality is that many businesses are already non-compliant without actually realising it. The reason is very simple. Most business owners think consumer law only applies to large retailers and it's not something they need to think about. Or e-commerce businesses, or companies that sell direct to consumer. But if your customers are consumers, whether you're selling products, memberships, subscriptions, courses, events, software or services, this matters. And it matters far more than it did a few years ago. Historically, consumer protection law was often viewed as something of a bit of a paper tiger. Yes, rules existed, they were there, regulators could investigate, but enforcement was relatively slow and often required court action to really have anything done about it. But that is changing. The Digital Markets Competition and Consumers Act gives regulators significantly more power to investigate and enforce breaches. In simple terms, the risks of getting this wrong have increased substantially. And the first thing I would say to founders is this: do not assume that consumer law is just about fraud. Most businesses that get into trouble aren't trying to mislead anybody. They're simply operating in ways that have become normal to them. The problem is that normal doesn't necessarily mean compliant. So let's start with something we all love to hate, online reviews, because this is one of the biggest changes. Most businesses understand that fake reviews are a problem, but many don't understand how broad the rules are actually becoming. The focus isn't just on posting fake reviews, it's on how reviews are actually collected by businesses. It's about how they're monitored, whether businesses can demonstrate they are really genuine reviews, whether positive reviews are being selectively promoted, whether negative reviews are being suppressed. Think about how many businesses proudly display 5-star ratings on their websites. Could they actually demonstrate that those reviews are genuine? Could they explain their review verification process? Many actually couldn't, and that is where the risk is starting to emerge. The second area that we need to think about is pricing. This is where I think a huge number of businesses are actually quite exposed. Founders are often focusing on what they charge. Consumer law increasingly focuses on how that price is presented to the consumer. Can customers clearly see the total cost? Are mandatory fees disclosed up front? Are there additional charges that are added later in the purchasing journey? What regulators are increasingly targeting is something known as drip pricing. That's where a customer sees one price initially and then discovers additional unavoidable charges later in the process. Now, let's think about your own business model. Could a customer see the true cost of what you're selling within a matter of seconds? Or do they need to click through several pages first to get to the final answer? Because that distinction really, really matters. The third area is subscriptions, and this affects far more businesses than people are actually realizing. It affects software businesses, it affects membership organizations, training providers, professional bodies, coaching businesses, community platforms. Increasingly, regulators are focusing on how subscriptions are sold and renewed. Can customers easily cancel? Do they understand what they are signing up to? Are renewal processes transparent? Are reminder notices being sent where required? Many businesses have built recurring revenue models over the last decade, but the challenge is ensuring that those models remain compliant with the new laws. Then we come on to marketing claims, and this is where founders often get themselves into a lot of trouble. Not because they're being deliberately dishonest, but because they're enthusiastic. Every business wants to tell customers why they're different, why they're better than the competition, why their product works, why their service delivers results. But the legal question isn't, do you believe it? The legal question is, can you substantiate it if it's a claim you're making? When you claim something is the best, when you claim it's the fastest or the leading, the most effective, the number one, what evidence do you have for that assertion? And if a regulator asked you to produce that evidence tomorrow, could you? Most businesses never think about this until a complaint arises. The irony is that consumer law is increasingly becoming a reputational issue as much as it is a legal issue, because modern consumers are empowered way more than they used to be. They leave reviews, they post online, they contact journalists, they complain publicly. 20 years ago, a customer might tell 10 people. Today, they can tell 10,000. And that means that compliance isn't just about avoiding regulatory action and staying out of trouble, it's about protecting trust in the brand. One thing I find fascinating is how many businesses spend enormous amounts of time protecting themselves against highly unlikely risks whilst ignoring highly probable ones. They'll spend weeks worrying about a shareholder dispute. Meanwhile, their website terms haven't been reviewed in years. Their refund policy is unclear. Their marketing claims are unsupported. Their subscription process is too confusing. Their reviews are not properly verified. The real risks are often hiding in plain sight. So if I was advising a founder today, what would I actually do? Well, I'd start with 5 key questions for that founder. First, could I explain my pricing model clearly to a customer in 1 minute? Second, can I prove my reviews are genuine? Third, could I justify every significant marketing claim that's on my website? Fourth, can customers easily understand how to cancel subscriptions or memberships? And fifth and finally, when was the last time somebody actually reviewed my consumer-facing terms? Because if the answer to that last question is, I don't know, you're not alone. Most businesses haven't looked at them for years. The final point I'd leave you with is this. The biggest legal risks are rarely the really dramatic ones. They're not usually the issues that make the national headlines. They're often the everyday practices that become normal inside a business. And that is exactly why they're missed. Consumer law isn't particularly exciting. It isn't glamorous, it isn't sexy, but in 2026, it may well be one of the most important areas of legal risk that founders should be paying attention to. Because whilst everyone is talking about AI, regulators are increasingly looking at how businesses are treating their customers. And those two conversations are actually about to collide.